Well, hello everyone, and welcome to Uncivil Law for the Thursday Night Thunderdome. Yes, it is the place where all the law stories come to battle in a battle royale format to figure out which story best story, because so many legal things happen throughout the week, we cannot keep track. And the Thunderdome is where it all comes to face its ultimate culmination. So we begin with news from the NBA as one player learns that, maybe the gambling on the sports is not great if you are a participant of said sport. What we call a conflict of interest. Conflict of interest. And we have some problems, so let's learn a little bit more about that. The NBA has banned a player. Toronto Raptors player Jontay Porter was banned for life from the NBA on Wednesday after a league probe found he had disclosed confidential information. That would be a no-no to sports bettors and wagered on the games, even betting on them to lose. See, that's a problem on multiple different things. We have some issues with the fixing of sports, and you want to give inside information, non-public information, to the bookies. That's a bit of a problem. You're not really allowed to do that. And you are certainly not allowed to bet on your own team to lose because, well, kind of a problem. Porter is the second person to be banned by the commission for violating the league rules. The other was the Los Angeles Clippers owner Don Sterling in 2014. Can't do that. In making the announcement, Silver called Porter's actions blatant. There's nothing more important than protecting the integrity of the game for our fans, our teams, and everyone associated with our sport, which is why Jontay Porter's blatant violation of our gaming rules are met with the most severe punishment. Yeah, I mean, that seems like a pretty easy thing, guys. I mean, it's like this is just wrong on multiple different levels. Doesn't really take a lot of legal analysis here. You're sharing inside information, which is wrong. You're betting against your team, which is wrong. So not really a great way to go there. The investigation started once the league learned from a licensed sports betting operation, an organization that monitors legal betting markets, about unusual gambling patterns surrounding Porter's performance in a game. There are a lot of people looking at this kind of thing, as you might expect. And there's we see some things that raise an eyebrow. In particular, we saw things in Porter's performance on a game on March 20th against Sacramento. The league had determined that Porter gave better information about his own health status prior to the game, inside information, and said another individual known to be an NBA bettor placed an $80,000 bet that Porter would not hit number set for him in parlays through the online sportsbook that would have won $1.1 million. Well, that's a pretty good bet. When the person you're betting relating to, Porter, is the one providing information. Hey, I'm just not really feeling that good today. Don't think I'm really going to be able to make those bets. Wink, wink, wink. Make those baskets. Wink, wink. Oh, let me bet $80,000 for a return of $1.1 million. What could possibly go wrong? Porter took himself out of that game after less than 3 minutes, claiming illness. None of the stats meaning total set in the parlay. What are the odds? Well, that's just easy. Hey, I don't think I'm going to make the numbers. How am I going to guarantee it? Well, 3 minutes into the game, I'm just going to take myself out of the game. And then I won't make the numbers now, will I? The $80,000 bet was frozen and not paid out because the bookies were perhaps a little bit suspicious, a little bit sus about perhaps this information. Maybe we should take a closer look at this and see if everything's on the up and up. Something seems potentially wrong. Maybe we should take another look at that. The NBA then began another investigation based on that. You don't want this for your kid, you don't want for your team, and we don't want for the league. That's for sure, said the Raptors president. My reaction is obviously surprised because none of us saw this coming. You know, when you're paying the guy uber money to be a basketball player, you think maybe he'll just be a basketball player, not be a rat, and not be a traitor to his own team and himself. That's nice. Later, after the NBA revealed the ban, the Raptors said they're fully supportive of the league's decision to ban Jonte Porter from the NBA and grateful for the swift resolution. We'll continue to cooperate with all the ongoing inquiries. I query whether or not the bookies might want to have a word with him, because he's making information on the down low. So some of the bookies may be less than fully responsible. So the licensed bookies were like, we're just not going to pay it out. The unlicensed bookies might have further thoughts for him on a more one-to-one level. Who can say? The league has partnership and other relationships with more than 24 gaming companies, many of whom advertise with the NBA. Silver himself has been a longtime proponent of legal wagering, but the league has very strict rules for players and employees regarding betting, as you might expect. And what Porter has done is found to be a violation of the rules, which states that any player who, directly or indirectly, wagers money or anything of value on any game or event in the association or the NBA G League shall, on being charged with such wagering, being given opportunity and, go away. So basically, you're just not allowed to bet on basketball. Long story short, or more to the point, NBA basketball. I suppose you can bet on basketball in other countries, if you like. But you're just not allowed to bet on any basketball game. You can bet on baseball, and you can bet on hockey, you just can't bet on the basketball. Why might that ever be? The most obvious conflict of interest ever. For every possible reason. And you do, it's like, hey, that's not gonna fly, man. So just don't bet on the NBA or the NBA G League with the basketball. Silver cautioned that this move was possible, stating that what Porter was accused of is a cardinal sin. Yeah, I mean, you're literally trying to fix the game. So that's a problem. Porter has not commented since the investigation began, has never played for the Raptors again. He was listed out of all the games for the remainder of the season, citing personal reasons. Personal reasons mostly being, I'm about to be fired. The league also determined that Porter, the brother of Denver Nuggets forward Michael Porter, placed at least 13 bets on NBA games using someone else's betting account. That would be the indirectly part. The bets wagered from $15 to $22,000. So he's giving information to somebody, and he's doing betting himself. No. Those wagers didn't involve any game in which Porter said for those bets, but not that it matters because it's a violation of rules to bet on any game in the entire NBA if you're a player in the NBA. Because, pretty obvious reasons. But 3 of the wagers were multi-game parlays, including a bet where Porter, who was not playing on the game, wagered on his own team to lose. And somehow, he managed to lose the bets, which is just even insult to injury. So not only is he using all this wonderful inside information, not only is he betting against his own team, but he's losing his own bets. That's just sad. With all the information in the world, he still can't get it right. That's just sad. While legal sports betting boarding creates an transparency that helps to identify suspicious or abnormal activity, they do have a few computer algorithms looking at it, as you might expect. They do have a few computers looking at it for unusual patterns. Few statisticians looking at the gambling to see if it, makes sense. The matter also raises important issues about the sufficiency of the regulatory framework, including the type of bets offered on our games and players. Working closely with the relevant stakeholders across the industry, we'll continue to work diligently to safeguard our league. Well, it sounds like you're doing fine since you figured it out. Porter was on a two-way contract, meaning he could play both for the Raptors and also the G League. So that's nice. He was playing for two different teams at once. How nice for him. He was playing for the Raptors and also the G League. How fun. His salary for this year was $400,000. And his salary next year was expected to rise to $2 million. But, not so much with the $2 million or the $400,000. And he'll be lucky if they don't sue him for the money back. And that's the end of that story. Well, golly gee whiz, guys, that didn't turn out very well for him, did it now? Yeah, that seems like a problem. So, maybe don't do that. Well, my friends, thank you for coming to the Thursday Night Thunderdome, where we learn all the stupid things, and there is, as we can see, unfortunately, an endless pile of stupid. The stupid apparently knows no bounds whatsoever. Unclear whether or not I can bet against myself as a lawyer. That'd be good. That'd be good as a betting market. I'll bet against myself. That'd be good. Throw this motion. That'd be good. All right. Yeah, unfortunately, we are done with the Daybell trial, my friends. We are just done. It didn't pan out the way that I had hoped, and we apparently, at least I made a better decision in streaming the Supreme Court case that we did, because we got 1,000 people watching that, as opposed to the 200 people that were watching the Daybell trial. So it just wasn't panning out. And, it just doesn't pay to do it every single day for 8 hours a day when you're not getting any watch time, or it just doesn't pay. So I gave it my best. And people just weren't interested. And it's time to move on. So, I'm not going to see the end of the Daybell trial. So that's just not happening. Daybell trial had a lawyer get sanctioned. That's interesting. I'm not going back. Thank you for your contribution. What happened with Daybell? It just wasn't successful for me. This is my full-time job. And I was not getting the people watching that I need to make this successful. I need to find things that make people interested so that people will watch it. So I can get ad revenue, so I can get super chat revenue, and also just because, it's more fun for me if I'm talking to an audience. It's just not very much fun if I'm not talking to people. So, we had 200 to 300 people watching Daybell, and the chat rate was something like 1 chat a minute on average. So most people were watching passively. People weren't chatting about it. There was no revenue coming in. So it was just not a useful, productive thing for me. So it now is like, I need to figure out something else to do. So, try to find something else that will be more productive. So, and for example, the Jan 6 thing we did today was much better. We had 1,000 people watching that at once. That was much better, much more enjoyable for me. Not that it brought in a massive amount of revenue, but we did have a few super chats, but not massively. But just having 1,000 people tune in is just more interesting. It's more fun for me. So, that's it. So we're done with Daybell. I'm not sure what went wrong. There's 10,000 people watching it live on East Idaho News. So there seems like there's an interest out there. I'm one of very few law tubers that's covering it. No one in LawTube is covering it. So I thought I'd have the field to myself. But for whatever reason, people aren't interested. And I ask people to tweet every day. I ask people to I asked people to tweet and hit the retweet, and maybe 10, maybe 20 people hit retweet, but it's not enough. It's not enough to get traffic. So it's like, well, I can't get promotion. People won't help me retweet it out. People aren't coming by, so it's just not a good use of time. So, what else can you do? What else can you do? Karen Reed? Maybe I'll give Karen Reed a try, maybe not. I mean, doing a trial is a huge amount of time. It's a huge time commitment. It is 8 hours a day. It's a long slog. It's a long day. So doing a trial is a long slog. You think Karen Reed's where it at? Okay, maybe we'll give Karen Reed a try. I guess. Does it start on Monday? I mean, maybe we could give Karen Reed a try and see if people want to watch that. I mean, again, they had 10,000 people watching the trial on East Idaho News, so someone's watching it, just not watching it with me. It could be me. EDB's doing Karen Reed? Okay. Well, maybe I won't do it then, because she's likely to get all the traffic. I could try. I mean, I could do Monday and see how it pans out. I can try Monday. You think a lot of people are trying it, so it's not good? Do you think you don't think it's good use of time? EDB says it starts on Friday. It starts tomorrow. I could give it a try. When does this thing start? I could give it a try and see if I get any traffic. All right. All right, this is... I don't even know what this is. This doesn't make any sense to me. They're doing jury selection on Monday. I'll skip jury selection. All right. All right, this goes back to that Tennessee school shooter. You may remember, this was a member of the LGBTQ contingent. I mentioned because his manifesto was never made public. Usually these manifestos are made public, but this particular manifesto was not made public. And the speculation has been because the manifesto is not compatible with the message. And so they're trying deliberately to withhold publication of the manifesto because, well, it's not, an angry white male who did it. It's a member of the LGBTQ contingent. And so we can't have their thoughts publicized because it's not compatible with the message. So the victims, or the families of the victims more properly, are trying to claim copyright over the school shooter's writings, which doesn't make any sense. But we're going to try. And a Tennessee judge on Wednesday seemed ready to agree with an attorney for the Nashville police. The writings of the school shooter could be released as public record once the investigation's closed, which makes sense. I mean, that makes sense. But the parents of the children at the Covenant School add an extra twist to the already complicated case by asserting they've gained legal ownership of writings from the school shooter's parents and now hold copyright. Which doesn't really get you to the end of the page either, incidentally, because even if you own copyright in it, it doesn't necessarily prevent it from being published, which I know kind of sucks maybe, but it's a public record. It's a public record, so you can't copyright a public record. I suppose you can, you just can't copyright it from the public record. So it doesn't make any sense. All right, but they want to try to do that. None of the 8 attorneys arguing before Davidson County Court, Chancery Court. They still have a Chancery Court in Tennessee? Lord have mercy. All right. All right. Once upon a time, in the long, long ago in the far, far away, the courts of law and equity were actually separate courts. The concept of equity in law goes back a very, very long way. Very, very long way. But they were separate concepts. They were separate concepts in the common law. And so equity as a concept is not new in law. And it used to be the case in most states, well, I think many states, but it used to be the case that there were separate courts for law and there were separate courts for equity. And most states kind of decided after a while that was dumb because, well, it just seems inefficient. But apparently, the great state of Tennessee still has chancery courts. They still have separate equity courts. That's dumb. Anyways, their answers to Myers' point questions about the interarray of federal copyright protections and the Tennessee Public Records Act seems at times only to muddy the waters further. In the end, Miles says she'll write an order outlining specific questions he wants them to address only after she'll rule on that if the writings can be released. Copyright, yeah. Copyright is not it. You know, that doesn't make sense. The copyright belongs to the author, which is the shooter. Upon his death, it would therefore go to his estate, which is presumably his parents. And they're trying to claim that the shooter's parents assigned it to the victims or something. Did they register their copyright? Incidentally? And also, like, the copyright doesn't prevent it from being obtained from the public record. That's not how that works. You can't copyright it out of the public record. Sometimes the public record includes copyrighted material, but that's not how that works. That's dumb. Police say the writings they've collected as part of their investigation into the March 27, 2023 shooting at the Covenant School that killed 3 9-year-old children and 3 adult staff members are public records. Yeah. However, they said they cannot be released until the investigation's concluded, which sounds like some bullshit in and of itself, but, you know, whatever. The LGBT can suck my ass when it comes to pronouns. Those asking the writings be released immediately include news outlets, a Tennessee state senator, a gun rights group, and law enforcement nonprofits. They argue the open records is a formality at this point. The shooter was killed by the police at the scene and no other suspects have been identified. Meanwhile, 3 other groups have been allowed to intervene in the case, arguing that none of the writings should ever be released. In addition to the copyright issue, which sounds like some bullshit, attorneys representing the Covenant parents, the Covenant School, and Covenant Presbyterian Church presented a united front in arguing the writings fall under Tennessee law that protects the privacy of information, records, and plans relating to school security. No, it doesn't. It wasn't created by the school. That's some bullshit. Given the law as broad as possible reading, the writings could inspire copycats and threaten the security. That's some bullshit. Myers seems to take exception to that interpretation. Right now, you're asking me to adopt an interpretation of the statute that information written in a journal should be construed as a plan relating to school security, which doesn't make any sense. She noted any decision she's sure to make will be appealed and will have to apply scrutiny of a higher court, I'm sure. Eric Osborne, the parents' attorney, had another reason to keep the writing secret. All the children in the Covenant School are victims of the Tennessee Constitution and have the right to be free from abuse, harassment, and intimidation. Releasing the writing publicly could harm the children. That's also some bullshit. Is harm, at least the judge is asking the right questions because it's some bullshit. Is harm synonymous with harassment, intimidation, and abuse? You're asking this court to create new law. Miles offered the example of a victim undergoing cross-examination in a criminal trial. It might be upsetting, but that's not a violation of rights. Duh. Miles adds she reads the law to protect victims during the pendency of criminal justice proceedings. To say it's in perpetuity, I don't see it. He replied that there's no expiration. Once you're involved in the criminal justice system, you have constitutional rights that Tennessee gives to all victims. Bullshit. Miles then asked whether there might be some parents at the school who want their writings released. You represent your client's interests. What are you asking the court to do? Puts a bar on what they want. Are you elevating one group's parents over another? Osborne said 103 of the 112 families with children at the school attack have signed a petition that the writing should be suppressed. Apparently, there's a lot of parents who want to please the LGBTQ contingent. So that is some of the things that are happening there, and the LGBTQ contingent can continue to suck ass as they always have before. Moving on. All right. In gold theft news. Until someone on their side of the aisle can define what a woman is in a non-circular way, until they can define what a woman is without it being tautological, they can kiss my ass. Nine arrests have been made in a $14.8 million gold heist that occurred in Toronto Airport, with only a fraction of it so far recovered. Yeah, you knew that was going to happen. 9 people have been arrested and search warrants are out for 3 others in last year's $15 million gold heist from the Toronto International Airport. Police have only recovered 6 pure gold bracelets worth $65,000, so not so much so far. Authorities announced the arrest of the 1-year anniversary of the heist. Police say 6,600 bars of pure gold weighing 400 kilograms and foreign cash amounting to $1.8 million were stolen in the heist. They believe the thieves melted down the gold, sold it, and then used the profits to purchase illegal firearms as part of a trafficking operation. We might want the gold back. Police have seized $300,000 worth of cash, which they believe which might be some of the profits related to the theft. Police have also seized smelting pots, cast, and molds, which they believe were used to change the composition of the bar, which is a pretty good bet. They also found 2 lists accounting for $7 million and $10 million at 2 separate locations. A common term in drug trafficking investigations, we believe these lists actually show where the money was distributed when the gold was sold by the suspects. Wasn't it in Goodfellas? It's a lot like Goodfellas, yes. You know, I was watching that documentary. I was watching a clip from that documentary, Matt Walsh's What is a Woman, when he was interviewing that professor, the woman studies professor, this male woman studies professor who refused to answer any questions. All he would do is ask questions. He wouldn't answer any questions. And it was so fucking irritating. It made me want to get up there and just slap him across the face. Canadian police worked in cooperation with the Philadelphia Field Division of the U.S. ATF, which arrested one individual in the U.S. who had 65 illegal firearms in his possession. Well, that'll certainly get someone's attention. He was stopped during a routine traffic stop, which it's amazing how many of these things are cracked by a routine traffic stop. It's truly amazing. He was later identified as the driver of the truck during the heist. Police are still searching for a former Air Canadian employee who they say helped the thieves and 2 others who were involved. The gold and foreign currency stolen in the heist were ordered from a refinery in Zurich. They had been transferred on Air Canada flight to Toronto. Shortly after the plane landed, the gold and cargo were transported from the plane to a cargo facility. A suspect driving a 5-ton truck arrived at the facility later that evening, providing a fraudulent airway bill, and received the shipment. It's true. You can get away with anything if you just have a clipboard. The airway bill was a duplicate of one used the previous day to pick up a shipment of seafood. So apparently they found a copy of a real air bill, and they, transformed it to say, instead of seafood, how about gold? They probably loaded the truck for them. The container containing the gold and foreign currency was then loaded on the truck with them driving further away. Fantastic. So that is ongoing. How can we make the Thursday Night Thunderdome more popular? That's the real question. How can we get the kind of numbers for the Thursday Night Thunderdome that Rob or Ian get for their respective streams? That's the real question. And more of the point, how can I get the kind of super chats they get? That's even more the real question. So that this thing can sustain itself. And I can occasionally eat. All right, in whistleblower news. You'd like an agenda? Do either of those channels give you an agenda in advance? Okay, no? All right, pressing on. Whistleblowers have outlined allegations of nepotism and retaliation within the Albuquerque Police Academy. All is not well in Albuquerque. It may be the destination that Bugs Bunny was always trying to get to, and it may be where the meth is. But yeah, they put hot topics in their description. You really think that's what it is? The topics in the description, you really think that's what it is? You think the topics in the description is what's causing the issue to the tune of 10 to 20 or more to 1? I'm somehow doubtful. Several members of the Albuquerque Police Academy's training staff who were dismissed from their duties last summer filed a lawsuit Wednesday outlining allegations of nepotism and retaliation by leadership within the force. The whistleblower complaint centers on the requirement that male cadets shave their head with a razor daily. That's pretty intense. Every single day. One cadet, the son of a police commander, was found to have violated the policy and was not initially truthful with the training staff when asked whether he was following through with the practice. The cadet was dismissed from the academy late August following internal investigation, but the lawsuit states the decision was reversed within 24 hours. The plaintiff deduced the commander had intervened on behalf of the son and that they were dismissed from the academy and reassigned to other positions in the field because they reported the violations. So, special treatment for special people, and then the people who complain about it are retaliated against. What else is new? In a letter to the police chief, the plaintiff described an abuse of authority and suggested the commander's intervention was inappropriate and nepotistic. We've done nothing wrong, they stated in the letter, which was submitted as part of the complaint. We've acted to report ethical violations and protect the public interest and ethically trained law enforcement officials, and we should not suffer retaliation in doing so. Fun. It wasn't until a month later the department responded with a notice that an internal investigation will be initiated. I'm sure that's going to get everyone involved, and would include possible hazing of a cadet. According to the lawsuit, the academy's commander, who had instructed training staff to reinstitute old school policies and more military style training at the academy. So that is what is happening in that case. Let's see what happens next. In your girlfriend may be into you just for the money news. A woman has scammed her online boyfriend out of $1.2 million to finance her lifestyle. I mean, guys, come on. Have some self-respect for yourself. Lord. Just Lord. A Texas woman admitted to scamming more than $1.2 million out of her online boyfriend to finance her lifestyle. I mean, there are simps, and then there's whatever this guy is. Prosecutors say that 46-year-old Lorraine Marie Rue befriended the man from Indiana on social media and began a relationship with him. From October 2020 to February 2022, Rue told the man that she needed money to pay for her daughter's surgeries, along with heart medication for himself. The man gathered the funds by drawing from his personal IRA, a mutual fund, checking and savings accounts, along with cash advances and personal loans. In reality, Rue did not have, nor her daughter had accounts with the hospital. She used the money to gamble at numerous casinos in Oklahoma. Investigators said she visited one casino 157 times over 6 months. To cover up her lies, the 46-year-old woman made fake emails accounts pretending to be her employer and promising the man would be reimbursed. Sadly, this is a case in which the victim's heart was in the right place. No, he's a simp. He's a simp. You know, for the life of me, I don't understand why men give such huge amounts of money to people, whether it's OnlyFans or otherwise. I just don't get it. Why would you do that? What are you hoping to get out of it? It's like in the amount of money that these people are talking about, right? It's just sad. It's just sad. Rue pled guilty to corrupt business influence and 2 counts of counterfeiting. Last Thursday, he was sentenced to 4 years, but awarded a year's jail credit. So, not much punishment there. Holy shit. I mean, I'm willing to dress more sexy if that's the thing. Do I need to wear cleavage or something? Do hot tub meta? Is that what we're in? I mean, I could get an indoor hot tub like all the good streamers. I get myself a mirror so I can show off my ass. As I jiggle. You'd like that, wouldn't you? You'd like that. I could do some ASMR. Lick the microphone. Oh, wait. It was probably not very good with the foam cover on. Hold on, sorry. There you go. I'm happy to help. I'm in a decent mood. That doesn't help. Oh, man. What else is going on? I'm not quite sure I understand the headline of this story. Why'd you tune in? Yeah. Why don't you donate to Uncivil and he'll stop licking the microphone? How about that? That'd be good. I think we read that before about the family suing the bar for serving their teenage son. Although last time I think it was a Chili's. Well, we have another one that's the Bar Twins Peaks, so I think we'll skip that one. Good news. I think I have a rough draft done of my complaint. And now I just need to find people to like edit it and stuff. Alright, I don't know about this one. What else is on the agenda? We could sue Jelly Roll being sued by Jelly Roll. That's fun. We'll try that. What the hell is this? Okay. So this is two performers who use a similar name. All right. All right. So stand-up comic Jelly Roll has been sued by Philadelphia area wedding band Jelly Roll over trademark infringement. I mean, yeah, I mean, they are both in a very similar domain, so that sounds very plausible to me. A popular local wedding band is taking on a chart-topping country artist for allegedly harming their business. Do you have a registered trademark? Do you have a registered? That'd be nice. In a lawsuit filed last week, Jelly Roll, the band, sued Jelly Roll, the singer, well, or comedian, I think, claiming they first adopted the name in the 80s. The plaintiff, professionally known as Jelly Roll, is providing musical and vocal accompaniment for celebrity events throughout the Delaware Valley since the 80s. The 39-year-old country star, whose real name is Jason DeFord, was born 4 years out after the band started performing in Philadelphia. Defendant, who was not born until 1984, claims in a published interview that his mother referred to him as Jelly Roll as a small child, which if your mother's referring to you as Jelly Roll, things are not going great. Jelly Roll's similar name and recent successes hurt the wedding band in searches. Now, any such search on Google returns multiple references to the defendant, perhaps as many as 18 to 20 before any reference to plaintiff entertainment dance known as Jelly Roll can be found. Well, they say circular, so they have a trademark. So if they have a registered trademark, they should be able to win this fight. If they have a registered trademark, they should be able to win this fight. In addition, the lawsuit claims the singer's past incarceration for felony robberies harmed them. Yeah, if they have a registered trademark, if they're on the register, this is too close, and they should win that fight. So, go Jelly Roll, go. So Jelly Roll, the singer, is going to have to change his name. Sorry. Or buy them out, one of the two. All right, in a sort of tragedy situation, an Ohio man fatally shot an Uber driver after a scam phone call targeted both of them. So some confusion about who the bad guy was, leading to a fatality, which incidentally, by the way, probably means whoever did the scam is guilty of manslaughter, if not felony murder. So, I hope you enjoy that one. So whoever tried to do that scam got way more than they deserve, got way more than they bargained for. An Ohio man who authorities say fatally shot an Uber driver who he thought was trying to rob him after a scam call deceived them both has been indicted on murder. Which it may very well be for the shooter, but it's going to be something for the person who tried to do the scam as well, I think. William Brock, 81, also faces counts of kidnapping and felonious assault. Court documents do not list an attorney. He has pled not guilty and faced a life sentence, which for an 81-year-old, probably not that much time. The shooting occurred March 25th at Brock's home in South Charleston, Ohio. Officers for the county sheriff responded there after Brock called 911 and said he shot someone who was trying to rob him. Brock had received scam calls from someone pretending to be an officer from the local court who eventually began making threats and demanding money. The victim, 61, was an Uber driver who had been told to retrieve a package from Brock's home. A request, say, was made possible by the same scam caller or an accomplice. They are going to track those people down, ma'am. They are going to track those people down. Hale had no knowledge of the calls made to Brock. When she arrived and got out of the car, Brock pulled a gun and demanded she tell him who made the threatening calls. He also took Hale's cell phone and would not let her leave. When Hale tried to get away, Brock shot her once, then shot her 2 more times as he discussed the situation. Brock sustained a minor head injury during the confrontation and called 911. Hall was taken to the hospital but died later. Yeah. The original scam calls are under investigation. I bet they are. Someone's going down for manslaughter or felony murder. They are in the U.S. Well, either way, it wouldn't matter. I mean, legally, it wouldn't matter. We have to track them down. But strictly speaking, we can charge them no matter where they are in the world because their crime manifested in Ohio, which means Ohio has jurisdiction on them no matter where they are in the world. So if we can find them, and the United States has an extradition treaty, you know, we might be able to get them no matter where they are in the world. We'll see. Was it extortion? It doesn't seem like it was extortion. It seems like what happened is the scammers called the guy and said, you got to give us money, and then sent the Uber person to the house to collect the money, to then somehow transport the money to somebody, which presumably means there's a local contact, or we're going to wire the money or something, but that seems to have been the scam, right? The scammers call the guy, the old guy, and say, you know, we're from the court. If you don't give us money, we're going to come after you. And then they sent the woman there to collect the money, and the confrontation happened. So that seems to be what happened. And because it manifested ultimately, because the fraud was the felony, which occurred in Ohio, that means Ohio has jurisdiction on it, no matter where the scammers are in the world, because the crime occurred in Ohio, which gives them subject matter jurisdiction. So if we can find them, we can extradite them, maybe, from anywhere. So run hard, I guess. Should I go back to licking the microphone? I haven't seen any donations and super chats for a while. Would you guys like me to go back to licking the microphone? I can do that for a while. In Florida Man news, we express our feelings with pizza dough. Florida man is arrested after allegedly pelting his roommate with pizza dough. A Florida man was arrested earlier this month after he allegedly pelted his roommate with pizza dough because he was making coughing sounds he didn't like. Well, getting on a cough drop might be much more helpful, by the way. Joseph Tressel, 32, was charged with criminal mischief and simple battery. According to the affidavit, at around 7:20 p.m., Tressel was making pizza. The arrest affidavit said Tressel heard voices telling him how to make the pizza. Thank you, Cool Springs, for the 20 gift memberships. We will not have to lick the microphone. I appreciate your donation. That's when Tressel allegedly grabbed a pizza dough from the floor he had already thrown away and threw it at his roommate. The pizza dough struck him in the hip while he was sitting at the dining room table, leaving no bruises. After the incident, Tressel allegedly went into his roommate's room, grabbed his dresser, slammed it down, and pulled the drawers out. This caused damage to the dresser frame. He did this on the way to his room, which is on the same path. In a post-Miranda interview, Tressel said he struck his roommate with pizza dough because he was making coughing sounds he did not like. Additionally, Tressel said he slammed the dresser down because he was angry at his roommate. Wow, that's a thing. That's definitely a thing. In perhaps unsurprising news, the Ford Bronco that was infamously used in the O.J. Simpson chase is up for auction. I mean, it's a good time to go for auction just after the man's death. I mean, the value of that item has got to shoot through the roof. So do you want yourself a 1993 Ford Bronco? The current owners, Simpson's former agent and two longtime friends, plan to cash in with renewed interest. I bet they do. The owners told the news that the last offer they received was $750,000, which is a lot, but they're hoping to get at least $1.5 million in a public or private sale. Before OJ passed, we always thought this was going to be the year we'll sell it because it's the 30th anniversary. Who knows if we'll be around for the 30th or 40th? How cute. About 100 million people watched the chase happen. I was one of them. Simpson eventually arrived in his Brentwood home where officers negotiated with him to surrender relating to the deaths of Nicole Brown Simpson and Ron Goldman. And with the unfortunate passing of O.J. Simpson, I suppose he is no longer looking for the true killers. So hopefully someone will pick up that cause. For 17 years, the SUV was reportedly parked at a condominium garage, and then it's made its way to the Luxor Hotel Casino, where it was used briefly to help open a sports museum. The current owners originally apparently paid $75,000 for the Bronco in the 90s. So, well, if you want yourself a used Bronco, there it is in all of its used Bronco glory. It can be yours. There were two Broncos? Well, this is the one that was the chase. I think there's only one chase Bronco. You've been getting calls from a local number asking you to call them back? Block them, man. Block them. Block them hard. Or I'll call them for you on stream if you want. It could be hilarious. You want me to call them back on stream? I'll call them for you. We can see what scam it is. It'll be exciting. What do you think? You want in? If you grab the number next time, that'd be interesting. All right. In, I think, our last story for the night, one last Florida night to crank the thing. A Florida man, while being arrested, asked the police if he can drink a beer. A Florida man, who was wearing sunglasses at night, asked officers to let him crack open another Colt one shortly before being arrested. The man had allegedly fired a gun in dispute with his neighbor. The Port Orange Police Department said officers responded to a dispute between the neighbors shortly before 9 on Tuesday. Body cam footage shared by the police department shows the complaining neighbor alleged his neighbor drove by earlier, opened his window, and telling him he was going to shoot me. At that moment, a shot can be heard in the area. You see what I mean? The complaining neighbor said. Several neighbors were outside at the time of the shot. Officers followed the sound and followed a suspect, Brent McPeak. That's it, I'm telling you, a woman can be heard saying. An officer directs McPeak to show his hands and stay where he is. I'm cracking this beer, okay? McPeak said. Nice. The officer asked McPeak if he had any firearms. He said no. The officer asked if there were firearms inside the house and said yes. Speaking over the radio, the officer said McPeak had 2 beers in his hand. This beer is cold, sir, and I want to drink it. McPeak said, come check me. The officer declined and said, well, I'm going to drink this beer. Is that cool? McPeak insists he'd done nothing wrong. He then complied with the orders to keep his hands up and was arrested without incident. According to the police, McPeak was not in possession of a firearm when taken into custody, but a search warrant executed the property, turned up 2 handguns, one of which was a .38 special revolver with a spent casing. McPeak was booked in county jail with no bond on charges of aggravated firearm and use of a firearm while intoxicated. That's exciting. I'm not very good at the scam calls. I don't get that many scam calls because I'm too cautious. I don't give them the answer they want. You know, so they hang up on me after a short while. I haven't gotten a spam call. I haven't gotten a spam call in a hot minute, though. I'm not gonna lie. I haven't gotten a spam call in a hot minute. I feel deprived somehow. All right, I think that will conclude us for today. Thank you, as always, to my mods for putting together these stories. It does really help. I do appreciate it. And putting things together. I feel like I need a shower, just generally. Not apropos of the stories, just feel like I need a shower generally. And maybe some more chili. Yeah, you don't answer phone calls? I don't either. Yeah, I don't answer phone calls either. After what I did with the mic, you're gonna need a shower? That's funny. Sound like it's raining? It's not raining. What do you mean? Sounds like it's raining. There's no. What sound are you talking about? Oh, you mean where you happen to be? That sounds like you're raining at your house. Oh, okay. Well, that's information that was helpful to share. Oh, you mean here, not there? Okay, yeah. It's clear. 78 and clear right now. All right, I guess I'll sign off for now, guys. It's been fun. And we'll talk soon. All right, bye-bye. Don't even start with a high-pitched whine. I will find you.